difference.
All right. Well, what I'm telling you all, according to the law, you cannot come before the court and tell the court, I want to be on probation for 5 years only. Y'all are not allowed to enter that agreement, period.
Now, Judge, you do not have to follow that agreement. That is correct.
That is not a part of your plea bargain agreement, counsel. The court decides the length of probation that somebody is on. The attorneys, Leonardo Carlos. Court is calling 2023 CR 8667, State of Texas versus Leonardo Carlos. Can I have parties announced for the record for the state?
Daniel Escobar,
Defense.
George Sharman on behalf of Ms. Carlos.
Are you Mr. Carlos? Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Carlos, did you review the document entitled True Bill of Indictment with your attorney?
Yes.
And did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
you are good.
Showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes,
Did you
sir.
sign it?
Sure.
Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney?
Yes, sir.
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Sure.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Carlos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised?
Up to this point, the hearing appears routine. The paperwork has been reviewed. The defendant has acknowledged the charges, and the plea process is moving forward. But a disagreement over one legal detail is about to interrupt everything, raising a question that neither side seems prepared to answer in the same way.
There's a $500 fine. State recommends community supervision. This will run concurrent with County Court Cause number 710098, 71099. Take in consideration 2023 CR 6643, County Court Cause number 713955, 713958, ignition interlock for half the term, victim impact panel, and DWI intervention. Did you understand that to be your plea?
Yes, sir.
Defense, is that the plea?
The plea includes an option of either 10 years jail, 10 days jail.
That's outside the plea bargain agreement.
It's in our plea bargain.
No, it's outside.
It is part of our plea bargain.
What I'm telling you, counsel, is this is your plea bargain agreement. This is outside the agreement.
So it is my understanding it's part of our plea bargain.
All right, I'm telling everybody it's not a part of the plea bargain agreement. Note, this is what it reads. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and condition of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement. However, the state or both parties make the following non-binding recommendations. And what it says is 5 years community supervision, TAP evaluation, 120 hours of community service restitutions, 2-year driver's license suspension, 10 days house arrest in lieu of 10 days Bexar County jail. That's not a part of your plea bargain agreement. You all can present that to me and I can either follow it or not follow it, but that's not a part of the plea.
Is the 5 years probation part of our?
No, it is not. The court determines the length of the probation.
And if you reject that 5 years, then it's a rejection of the plea bargain agreement.
No, if I don't follow your length or your suggestion for the length of probation and I give you, let's say I were to give you 8 years on probation or 4 years on probation, that's not a part of your plea bargain agreement, and I have not violated your plea bargain agreement because the court determines the length of probation, not attorneys.
Then, Judge, I think we can't go forward with this because our understanding of what a plea bargain agreement differs.
All right, well, what I'm telling you all, according to the law, you cannot come before the court and tell the court, I want to be on probation for 5 years only. Y'all are not allowed to enter that agreement, period.
Now, Judge, you do not have to follow that agreement. That is correct.
That is not a part of your plea bargain agreement, counsel. The court decides the length of probation that somebody is on. The attorneys do not. The attorneys just make a suggestion. I'm going to read it again. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions.
This exchange isn't just about a number of years on probation. It's about who has the legal authority to make that decision. The judge is drawing a clear line between a negotiated recommendation and the court's independent power, and that distinction is now driving the entire hearing.
For example, if I were to say, okay, you guys have agreed that he's to have probation, and I say I'm not giving you probation, then I will have violated your plea bargain agreement. But the length of time, the conditions, that's completely up to me. You all can't enter into a plea bargain agreement telling the court what your conditions will be.
That is not my understanding of the practice in this county.
Well, if people are practicing that different in this county, and I don't want to be mean to anybody, but if people are practicing that differently, then they are practicing the law incorrectly because the court decides the length of probation. Nobody else does. Defense attorneys don't decide the length of probation. The state doesn't decide the length of probation. The court does. Nobody else does.
Well, I guess my concern is moot at this point unless you do not follow our agreement.
Well, the question becomes, what do y'all think you have agreed to? Because if you think you've agreed to how long he's going to be on probation, that's not a part of your agreement. So if you all want to reread your contract, you're more than welcome to reread the contract. If you all want to go forward, you can go forward.
Well, Judge, I guess I need to review that comment
Sure.
and we'll come back to it.
All right. And State, if you want to show him.
Words based on the court's understanding.
No, based upon the law, counsels do not get to determine the length of probation or the conditions of probation. That's not my understanding. That's the law. If people want to get that law changed, they need to talk to the legislature.
Well, it's been my understanding and that's practice in this county that the judges allow us to do that.
Well, I don't want to disparage any judge, but guess what? They're wrong. Because according to the law, according to that document that y'all have just signed, the court determines the length of probation. Nobody else determines the length of probation. The court does. So if the state is asking for 8 years probation as the length, I can say, you know what? I've read the facts of this case. I think the person should only be on probation for 4 years or 3 years. That's up to me. Or the state may say, me and the defense counsel believe the person should be on probation for 5 years. I may read it and think, no, that person should be on probation for more than 5 years. I'm allowed to do that. And guess what? That is not going against the plea bargain agreement that you've entered to. So if y'all want to discuss that, you can. But if other judges are saying, oh, the law is that's the plea bargain agreement, then those judges will be wrong. All right. Yes.
I'm not ready to go forward with it then.
Then we'll be in jury trial. All right. Macy Malone.
Present.
All right. So did they give you, and if you want to hand that back. CR 10366, State of Texas versus Claudel Carney. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Denny Callahan, defense.
And are you Claudel Carney?
Yes, ma'am. Good morning, Judge.
Good morning. All right, so this is a case that I needed time to think over, and this is the case probation. Is this the case where there is potential DDRF?
Yes, Judge.
All right. So this is what the court is going to do unless there's more argument by either side?
No, Your Honor.
After several rounds of discussion, the disagreement is no longer about wording. It's about whether both sides entered the hearing with the same legal understanding. The next response could determine whether this case ends with a plea or moves toward a full jury trial.
RF. So you're going to remain in custody until you transfer to their inpatient facility, and that's for mental health. You understand? If you would like, I can either sentence you to 5 years prison or either you can do this probation. Which would you prefer?
I'll do probation, ma'am.
All right, so the 10 years deferred, affirmative finding of deadly weapon, DDRF. There is going to be regular reporting by Zoom or in person. The mixed caseload, regular UAs. Are you receiving any type of SSI?
No, ma'am.
There's going to be proof of employment within 45 days of release. No employment as a home health care provider with minors. $300 hours of community service restitution. There's to be no contact with Ted Gonzalez.
Yes, ma'am.
And from reading the PSI report, it appears both parties were homeless.
Yes, ma'am.
Let's see. This one. Does anyone have a copy of the TAP evaluation?
On hand, Judge, I can find it later.
All right, Ms. Abrams, do you have the TAP evaluation?
Judge, let me double check.
I didn't see, from my memory, I didn't see any restitution to the complainant. Thank you.
He
Daniel,
got the cell phone back. There's no restitution, Your Honor. He was not injured.
All right, Ms. Abrams, will the DDRF, I'm assuming they can address the drug issue, or do I need to order that outside of that?
No, it's dual diagnosis.
Okay. We're going to do anger management. And after he's released from DDRF, will they set him up with Center for Healthcare Services?
Yes.
All right, so I'll put in here, Center for Healthcare Services upon release from DDRF. And we'll do field visits one time per month for 4 months upon release from DDRF.
Yes, ma'am.
And do you have any family here?
Yes, ma'am.
Do you have anybody who would let you live with them here, or they're not?
I was currently staying with my brother, and he passed away. So, but I'm still reside at that address, 6555.
Oh, no, you don't have to give us the address, but let probation know, okay?
Yes, ma'am.
All right, and there's to be no unsupervised contact with minors. And I'm arguing that no unsupervised contact with minors because until you have your mental health issues under control, you really shouldn't probably be around minors, you understand?
Understood. Yes, ma'am.
Probation, is there anything else he needs?
No, Judge.
Is there anything else you need from the court to be successful?
Oh, ma'am. I appreciate you helping me also for Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes,
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes, ma'am.
All right, we can go on the record. Here's the thing. You're on probation, so you need to stay in contact with your probation officer. You have mental health issues, so you need to stay in contact with your case manager. They'll
Yes,
probably give you one. You need to make sure you do all of those things. Do you understand?
yes, ma'am.
If there's a problem with the medication they give you, you gotta let them know what the side effects are. You understand?
Yes, ma'am.
Because if you don't talk to them, they don't know. In this court, to be successful on probation, communication is key.
Yes,
If there
ma'am.
is an issue and you feel like probation is not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am, I do.
Yeah. So from here on out, everything that you do, your range of punishment on this case, if you were to mess up, is up to life in prison. Do you understand?
Thanks for watching and subscribe my channel.